Thank you, Ms. Ellis and Mr. Arasas, for a very comprehensive discussion. Now, I will discuss to you the last part of our group report, which is calculation of risk. First, let's define what is a risk. According to Merriam-Webster, a risk is possibility of loss or injury or to expose to hazard or danger. According to William Prosser, he is the most influential legal writer on tort in the United States. The standard of conduct, which is the basis of the law of negligence, is usually determined upon a risk-benefit form of analysis. And those are, first, by balancing the risk in the light of the social value of the interest threatened. Second, probability and extent of harm against the value of the interest which the actor is seeking to protect. And third, the expedience of the course pursued. So, what's the rule in the Philippines? Well, it says what constitutes ordinary care vary with the circumstances of the case. Professor Richard Epstein says the norm is to give negligence a common sense, intuitive interpretation. So, what are the circumstances to be considered? First, gravity of the harm to be avoided. Second, utility of conduct or the social value it seeks to advance. And third, alternative course of action, dangers and advantages to the personal property of the act himself and to others. According to the Book of Aquino, reasonableness depends on the following five factors. And what are those? He mentioned first the magnitude of risk. It is more likely to be unreasonable the greater it is. Example, a man fighting for his life during the major surgery. There is a high probability that he would die. Second is the principal object, exposed to the risk, which is the object that the law desires to protect. Well, as said in the first example, the life of the patient this time is the principal object. Third is the collateral object, a person who takes a risk of injuring the principal object. Fourth, utility of the risk, the probability that the collateral object will be attained by the conduct which involves risk to the principal. And the fifth one, necessity of the risk, the probability that the collateral object will be attained without taking the risk. The risk becomes reasonable because of those mentioned considerations. So, what do you mean by reasonable man? Well, Aquino mentioned the following. First, the law presumes or requires a man to possess ordinary capacity to avoid harming his neighbors. Second, attributes of a good father of a family. This is the only standard of conduct used in the Philippines, embedded under Article 1173 of the Civil Code. Third, action of the child will not necessarily be judged according to the standard of an ordinary adult. It is mentioned in Taylor versus Manila Electric Railroad. Fourth, absence of negligence does not necessarily mean absence of liability. Well, this is supported by Article 2180 of the Civil Code and Article 221 of the Family Code in the case of minor children. Fifth, a person's weakness is not an excuse in negligence cases. Example, physical disability. Sixth, in a case of an expert, he should exhibit the care and skill of one ordinarily skilled in the particular field that he is in. Experts and professionals, like nurses and doctors in the medical field, are examples of this case. Seventh, in some instances, persons impose upon themselves certain obligations and non-compliance therewith will be considered negligence. Nature of activity is an example of which. Eighth, intoxication. Example, drunkenness led to the accident. Ninth, the insanity of a person does not excuse him or his guardian from liability based on quasi-delict. That's in Articles 2180 and 2182 of the Civil Code. And 10th, conduct to be expected of women is different from that of a man. Now, let's talk about circumstances to consider that may affect determination of negligence. There is this time. Article 1173 of the Civil Code states that The fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. Second is the place, which is important where the incident happened. Third, the emergency. Thus, the situation requires application of sudden emergency doctrine. What is this doctrine? The legal definition, according to Merriam-Webster, is a person who is confronted with a sudden and unexpected perilous situation not of his or her own making, and who acts as would a reasonably prudent person under the circumstances will not be held liable, even if later reflection shows that the wisest course was not chosen. In the jurisprudence, emergency rule applies, quote unquote, to an individual who suddenly finds himself in a situation of danger and is required to act without much time to consider the best means that may be adopted to avoid the impending danger, is not guilty of negligence if he fails to undertake what subsequently and upon reflection may appear to be a better solution, unless the emergency was brought by his own negligence. You can find this in the case of Valenzuela versus Court of Appeals. What else may affect the determination of negligence? Well, gravity of harm to be avoided, alternative course of action, social value or utility of activity, and finally, the person exposed to the risk. We now go over to a few most recent cases involving situations where negligence was evident. In the case of Philippine Rabbit, the facts are as follows.